Good morning, everyone. I will wait a few moments and then we'll go ahead and get started. All right, it looks like we have everyone in the room, so I will go ahead and get started. First, I believe we have a court reporter today, and I just wanted to check in and make sure you are ready for us to go on the record.
Good morning. Yes, I am ready. Thank you.
Thank you very much. Appreciate that. Good morning. It's December 16th, 2024. I am Nicole Kinsey, the presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference on the pending petitions for change of water right permits 16478, 16479, 16481, and 16482 of the Department of Water Resources for the proposed Delta Conveyance project. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. The audio and video are being recorded, and we will post files of the recording along with the Zoom-generated transcript to the administrative record on the board's FTP site. And once it is available, we will also be posting the reporter's transcript to the board's FTP site as well. And the YouTube recording will also be available on the AHO YouTube webpage. If at any time you're experiencing technical difficulties trying to communicate with us this morning, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov, or you can also send it to the Delta Conveyance hearing inbox. That works as well. There are a team of folks who are monitoring those inboxes and can let me know. And on that note, assisting me today are staff of the Administrative Hearings Office and the Division of Water Rights. If at any time I'm experiencing technical difficulties during the conference today and I'm not able to rejoin Zoom within a few moments, one of the hearing team will call a recess until I'm able to rejoin you. Hopefully that won't happen this morning. I did want to note for the record that it's raining, at least where I'm sitting. So we're going to take that as a good omen for our morning. I'd like to go ahead and move to appearances. I did issue a ruling on party status and tried to work through party status on Friday. There are a lot of parties, and I think we've already identified at least one error in the listing, and then some of you emailed us to note that there may be some other omissions. So we can talk through that in the meantime. But please do, if you have not already, please review that ruling from Friday. And if you believe you are a party and should be a party, you should be on the list of parties. And if you're not, please let us know as soon as possible. With that, I will identify each of the persons and entities that filed NOIs requesting party stat or identifying themselves as parties. And if you are representing that party or representing yourself, please unmute your microphone and state your name. And this is in no particular order, so bear with me. But we will start with the California Department of Water Resources.
Good morning, Hearing Officer Kinsey. Can you hear me? I'm talking through the Cloud Room conference line. So unfortunately, we were not able to rename it. So if you could do that for us, we would appreciate it. I'm joined here today with my colleagues Steph Morris and Ken Bogdan.
Thank you. Good morning. State water contractors.
Good morning, Miles Krieger for the State Water Contractors.
Thank you. Good morning. U.S. Bureau of Reclamation.
Good morning. Sorry about that.
That's okay.
This is Amy Oftenberg for Bureau of Reclamation.
Thank you. Good morning. Westlands Water District.
Good morning. This is Mary Loom for Westlands Water District.
Thank you. Good morning. South Delta Water Agency, Central Delta Water Agency, Heritage Land Company, and Rudy Musi Investments, LP.
Good morning. This is Dean Reese for those parties.
Thank you. Good morning. Byron Bethany Irrigation District.
Good morning, Kelly Tabor for Byron Bethany Irrigation District. Would you like me to state the other parties for which I'm
Please.
appearing today? Also, on behalf of the County of Sacramento, Sacramento County Water Agency, Sacramento Area Sewer District, and City of Stockton. And my colleague, Luwinda Lacey, is also here on behalf of those parties.
Thank you very much. East Bay Municipal Utility District.
Good morning, John Salmon on behalf of East Bay Mud.
Thank you. Good morning. El Dorado Irrigation District.
Good morning, Brian Polson on behalf of El Dorado Irrigation District.
Thank you. Good morning. Placer County Water Agency. Central Delta Water Agency.
Dean Reese for Central Delta.
Oh, I already called. I apologize.
Okay.
That was
Okay.
double on my list. At least you're twice here. Thank you very much. North Delta Water Agency.
Morning, Ms. Kenzie. Austin Cho on behalf of North Delta Water Agency and the districts within its boundaries, Reclamation Districts 999, 2060, and 2068.
Thank you. Good morning. I will leave it to you to list them all, but we'll start with San Joaquin County. Is it Ms. Meserve?
Good morning. Mr. Keeling is also here today on behalf of San Joaquin County, and then we have Contra Costa County Water Agency, Solano County, Richard Elliott, Frank Loretz, Friends of Stone Lakes, local agencies of the North Delta, and County of Solano. Also, I don't think that the representative for Save Our Sandhill Cranes could be here today, so I will be listening for him as well. Thank you.
Thank you. I appreciate that. And one to add, I think you may have said it. Is it Worcester Ranches LP?
Oh, thank you. Yes.
Yes, great.
I
Thank
got
you.
out my list, but I failed to read it properly.
Just want to make sure. There are so many parties, so I'm trying to keep track here. I believe the tribal entities are represented by a single person, but correct me if I'm wrong. Well, actually the Yale Law School cohort, if you will. Buena Vista Rancheria of Miwok Indians, Shingle Springs Band of Miwok Indians, Winnemem Wintu Tribe, Little Manila Rising, and Restore the Delta.
Yes, good morning. My name is Tara Bear. I'm a student attorney with the Yale Environmental Justice Law and Advocacy Clinic, and I'm speaking on behalf of Buena Vista Rancheria of Miwok Indians, Shingle Springs Band of Miwok Indians, Winnemem Wintu Tribe, Little Manila Rising, and Restore the Delta. And I'm here with my supervising attorney, Stephanie Safdie, and a number of clients, including Crystal Moreno with Shingle Springs, Gloria Alonso with Little Manila Rising, and Barbara Berrigan-Priya with Restore the Delta.
Thank you. Good morning. And good morning to all of you. California Indian Environmental Alliance. California Sport Fishing Protection Alliance.
Good morning, Ms. Kenzie. Chris Schutz on behalf of California Sport Fishing Protection Alliance. I do not believe my fellow protestants, Aqua Alliance or San Joaquin Audubon Society are present, although they may be with the numbers. So I'll speak up for them today. Aqua Alliance was not listed as a party, and I'd like to get to that at some point later today. Thank you.
Thank you. Yes, I had noted that too, so let's do that. What I'll plan to do is we'll go through the appearances and then we'll work through any issues on the party list. So thank you for that. California Water Impact Network.
Good morning. This is Roger Moore on behalf of California Water Impact Network. I was having a little technical difficulty before, so I hope you can hear me okay.
I can hear you fine now. Thank you. Friends of the River.
Ms. Kenzie, this is Gary Bobker at Friends of the River. I'll also note we're associated with a group of protestants, including Sierra Club and other parties.
And are there other representatives of those parties, or are you representing those parties today?
No, I am not. Bob Wright should be on the call.
Great. Thank you.
Good morning. This is Bob Wright, and yes, I am representing Sierra Club, California. Well, do you want me to list them now or wait till you call them off?
I'm ready. Please go ahead.
Okay, Sierra Club, California. Oh, by the way, on the list, Exhibit A, it just says Sierra Club. Could that please be corrected to say Sierra Club, California?
Yes, thank you for that.
Thank you. And then Center for Biological Diversity, Friends of the River, North Coast Rivers Alliance, Planning and Conservation League, and Save California Salmon. A total of 6 protestants.
Yes, and I have them. Thank you. I have them listed. Thank you. Good morning. With that, I will move to Pacific Coast Federation of Fishermen's Association and the Institute for Fisheries Resources. Do we have Mr. Spain? That's who I would expect. Golden State Salmon Association. Save the California Delta Alliance and Hood Community Council.
Good morning, Michael Brodsky on behalf of those entities.
Thank you. Good morning. San Francisco Baykeeper.
Morning, Eric Busher for San Francisco Baykeeper, and I will report back to Mr. Spain and Mr. Artis for PCFFA and Golden State Salmon.
Great, thank you. And then I have, I just listed Camp Lotus et al. I realize we just saw your NOI this morning, but do I have a representative from those parties?
Hi, this is Jan Dorman, and I'm listening for the Camp Lotus et al. Parties.
Thank you. Good morning. And we'll talk about that once we get through appearances. We'll talk about that, what may be a misfile. Ms. Deirdre Desjardins.
Yes, I'm here.
Thank you. Good morning. City of Antioch. Diablo Water District.
Good morning, Hearing Officer Kinsey West Miliband for Diablo Water District and also for the City of Sacramento.
Thank you. Good morning. And I believe we already had someone standing in for Save Our Sandhill Cranes. I think that was Ms. Meserve? Yes. That's what I wrote down. So thank you. San Luis and Delta Mendota Water Authority.
Yes, good morning. Rebecca Harms on behalf of the San Luis and Delta Mendota Water Authority.
Thank you. Good morning. Tulare Lake Basin Water Storage District.
Good morning, Ms. Kenzie. Peter Keel for the district.
Thank you. Good morning. Coachella Valley Water District. San Joaquin Audubon Society.
Dave Freeze for San Joaquin Audubon.
Thank you. And Mr. Freeze, I did have a question for you. I wasn't clear. I received the AHO received your email indicating your intent to participate in the hearing. Is it your intent to participate as a party or as and to present an opening statement or evidence or cross-examination, or is your intent to present a policy statement only?
We'll have present evidence.
Okay, thank you very much. I just wanted to clarify that.
Thank you.
Who did I miss? Those were the list. I'm going through those who should be listed as parties, at least to my knowledge. Is there anyone on the call? I see there's a hand. Mr. Krieger.
Yes, Hearing Officer Kenzie, I neglected to add that Kira Johnson of our office is also appearing for the state water contractors, and I will also be reporting back to Coachella Valley Water District. I'd also like to note that I actually have a hard stop at 12 o'clock today for personal reasons, and so I'd appreciate the opportunity to answer any questions that are directed specifically to the state water contractors. Thank you.
Thank you. I hope we won't go that long, so thank you. Ms. Bear.
Yes, I'm not sure if I missed it, but I just wanted to make sure that SIA, the California Indian Environmental Alliance, was on that list. They're represented by Sherry Norris, who is not here today, but we did file a notice of intent to appear for them.
Yes, I have her on my list here, and I think I did call out, but thank you for verifying that. I appreciate that.
Thank you.
Is there anyone else who plans to participate today who hasn't had a chance to introduce themselves? Wonderful. Okay. I think where we'll start is to work through any issues about party status. One error that we noted on our end was that we listed Desert Water Agency as a party. In reviewing the notice of intent to appear, I believe Desert Water Agency indicated an intent to present a policy statement only. So I think that from our position, they will be removed as a party and identified as presenting a policy statement. And I think that was just a misfile on our end. With respect to North Delta Water Agency, thank you for your very thorough response as to the mix-up. You will remain a party. We'll add North Delta Water Agency back as a party. It certainly wasn't. I realize, I just wanted to say to all of you, I realize there's been multiple deadlines for notices of intent to appear because we had pre-hearing conferences, and it's been a little confusing, and there are a lot of parties. So it's certainly not my intent to ding anyone on this deadline. It's just a matter of us sorting out who is planning to participate as a party and who is not, so that we all know going forward. So thank you. We will return North Delta Water Agency to the party list based on that good cause that well articulated in your filing. With respect to Camp Lotus et al., and I'll look, maybe you can relay this, Ms. Dorman. It certainly appears from what you sent to us that that was a timely filed notice of intent to appear. We will return those parties. I'm sorry, now there are hands. Let me pause. Let's go to Mr. Cho and then Ms. Meserve.
Thank you, Ms. Kenzie. As a first matter, we appreciate your attention to this and appreciate including North Delta. I just was going to seek some clarification regarding the status of Reclamation Districts 999, 2060, 2068, which were also listed in Attachment B. They are part of North Delta's protest, and North Delta is protesting on their behalf. So I just wanted to get some clarification on whether they're dismissed as parties or North Delta can continue to advocate their interests.
You're all in the reclamation districts too. And I thank you for that clarification because I did omit that.
Thank you very much.
Ms. Meserve.
Good morning, Hearing Officer Kinsey. Yes, just a quick question. Looking at the attachment B list, I see at least 4 of those, including Ecos and the Farm Bureaus, and Amistad Ranches that I am pretty sure want to participate as parties. So I was wondering if I could tell them to submit an NOI with an explanation as to how I just believe people were confused. I know among the attorneys we were discussing, is it necessary to file another NOI? And of course, I think, most of us did, but I could really see how it could be missed, especially for people that are thinking, oh, we're just going to get going on it when, the hearing actually starts, and that they don't have a lot of input on the procedural part of it that we're in now. So if
the short answer is yes, please do let them know. As I said, this deadline was not an intent to, to have one more hoop to jump through. It's just to sort out who intends to actually participate. There were multiple deadlines. It was confusing. What we ended up doing is looking back, and those parties that had filed, and we had a specific form for the pre-hearing conferences, and those parties who had filed those, we just took as intent to participate in the pre-hearing conference, but some filed standard NOIs and we carried those over, but it's been confusing. I would consider an explanation that there was confusion to be good cause in this case. If you would please have them get them in by the end of the week, and then what we'll do is issue an updated party list, and so that all of you can review it and make sure that there aren't any additional errors, so we can have this sorted out hopefully by the end of the year and know who is planning to participate as a party. So thank you for that note. And with Camp Lotus, I will return to that. It certainly appears to be timely filed. We will accept it and add those entities to the party list. Just a note, we did look back at our our internal archive, it looks like we didn't receive the email, although it looks like you sent it. So we will try to work with our IT folks. There are filters that we have no control over that sometimes filter things unexpectedly. And that's just, it doesn't happen very often, but it does occasionally happen with in our hearing matters. We will work with them to try to clear that up and get to the bottom of it so it doesn't happen again, hopefully. But it is just a reminder to all of you, please do check, and I know there are a lot of documents, but check the document index or check the administrative record on the FTP site. If your filing is not there, something may have happened. And that's the best way. If you file something, it should be up later that day or the next day. We usually move things pretty quickly. And if you don't see it there, feel free to email us and say, we intended to file this, we tried to file this, and we don't see it there. And we can try to minimize this kind of thing as much as possible.
So thank you, hearing officer, for that. And I apologize. I had I sent it without the attachment, then I sent it with the attachment. So there were multiple emails, and it may have thought it was spam at that point.
Who knows? The filters work in mysterious ways to me, but thank you for that, Ms. Dorman, and we will try to sort that out. And then I believe we wanted to turn back to Mr. Schutz. You mentioned Aqua Alliance. I mean, based on what we just discussed, I think we did not receive a follow-up NOI. That might have just been an omission, but I didn't know if you had anything else to add. If they're intending to participate as a party, if we could get an NOI this week, that would be fine.
When I filed my NOI, which apparently you got because I was listed as a party, Aqua Alliance and San Joaquin Audubon were also included on that NOI, and it doesn't seem to have registered.
Is this, Mr. Schutz, is this the NOI you filed back in August, or was it more recently?
No, ma'am, there was a more recent one.
That I don't think we received, because I think yours, if I'm remembering right, I think we carried over yours from before. Because of the standard NOI.
I will refile that. I apologize. I don't know what happened. I have had problems in the past, and I specifically send everything to you all from my Gmail account, which seems to go through. But I have had problems in the past with emails addressed to generic addresses at the State Water Board. So I thank you for your consideration, and we'll refile again. And I'd request that if you get it, please let me know.
We will. Thank you. And we'll work through it again. It may be a errant spam filter.
Thank you.
Are there any other issues with respect to the party list that any of you would like to bring to our attention?
This is Roger Moore. Can you hear me?
Yes, go ahead, Ms. Moore. Mr. Moore.
This isn't for an additional party, but there's one item that I think may need clarification as this matter proceeds toward hearing. We've reviewed your December 13th ruling, which grants party status to a number that filed timely notices, including the State Water Contractors Organization. What I wanted to point out is that I believe from the filings thus far, there's somewhat of an unresolved ambiguity as to what, if any, of State Water Contractors' 27 members they are representing in this proceeding. If I counted correctly, I think there are at least 6 individual members of the State Water Contractors that filed their own notices of intent and have their own representatives. I think it's also evident from both State Water Contractors' notice of intent and its concurrent petition for reconsideration that there are different positions among its membership that were not disclosed in the notice. Namely, the submissions of the State Water Contractors take an unequivocal position in support of the Delta Conveyance project that I believe is beyond what their individual members have acted on thus far. And the very same day that State Water Contractors filed their notice of intent, there was another one from one of their members, the Tulare district, that appeared to take the exact opposite position on the Delta Conveyance project. So it seems like as the matter proceeds, there may need to be clarification of which specific members, if any, have reviewed and consented to submissions of the state water contractors.
Thank you, Mr. Moore. So we can pause on this for a moment since you raised it. One of my questions is going to be why. Why should we get into this? I can understand for purposes of time allocation, groupings for cross-examination, that type of thing. The relationships may matter, and we want to take that into account. But in terms of, I mean, if State Water Contractors is purporting to represent its member agencies, I'm not sure to what extent do you view it as the role of the Administrative Hearings Office or the State Water Board to unpack that relationship?
Well, the guidelines we reviewed for interested parties that are, for example, posted on the board's website indicate they can support and oppose the project. In this case, the final action has not been taken on it, but to the extent that they have articulated positions, they clearly speak with more than one voice. So the potential risk that are, and I understand and appreciate that the December 13th ruling is made at what you I believe you described as an early stage of proceedings, which is understandable as hearings haven't started. But based on what's been submitted so far, it seems like they're not only we know already that there are going to be conflicting positions between the State Water Contractors organization's statements and one and perhaps more of their own members. As we get into the hearing issues, it seems like that might end up carrying a greater potential for confusion and prejudice than may have been apparent from the understandably general statement of interest that accompanied the notice of intent.
Thank you, Mr. Moore. Mr. Krieger, did you want to respond to that?
Just briefly, Hearing Officer Kenzie, I really don't think that we need to get into this now, but to clarify the notice of intent, the State Water Contractors Organization filed that. It was granted party status, and it's an independent agency, and so that is the party to the proceeding in light of the hearing officer's ruling. Each state water contractor has their own interest and can articulate that or advocate for that as they see fit. But the State Water Contractors, Inc., if you will, or the association is the entity that filed the notice of intent, is the party for this proceeding. To clarify that.
Thank you, Mr. Krieger. And Ms. Desjardins, did you have a comment on this issue?
Yeah, I join Roger Moore on the concerns, and particularly clarifying this with respect to the public interest considerations seems really important, and the prejudice issues. I think there should be an opportunity for parties to brief on this. I think it's an important consideration. Thank you.
Thank you. Mr. Keel, are you also speaking to this issue?
Yes, Ms. Kenzie, briefly. Tulare Lake-based Water Storage District isn't here to pick a fight with the water contractors at DWR over the project. We are here and we're granted party status because we have an interest in the water rights. No different than any other organization with interest in the project or Delta. So I don't think we need to go into representational issues.
Thank you, Mr. Keel. And when the time is right, I will be looking to your help and others to figure out where Tulare Lake belongs in terms of the order of things and groupings and time, and maybe it's you may be separate. I'm not sure, but I think we'll get to that when the time is right.
Thank you.
Thank you. Ms. Bear, I think I saw your hand earlier. Yes, if you would like to return to, I think it was probably not about this issue, but something else.
Not about this issue, but given that you raised the subject of confusion on deadlines to file NOIs, my clients have been hearing from several community-based organizations and affected members of the public, all of whom are non-parties to the proceeding, that they're interested in submitting policy statements, but did not have an opportunity to learn about the December 9th deadline for NOIs. And frankly, I think even if they had read the November 18th notice, the language of the deadline was not clear about whether it applied just to those who plan to give an oral summary of their policy statements in February, or whether it also applied to those who plan to just submit written statements, but not to appear to speak about them. And by contrast, the equivalent hearing notice in the sites proceeding had a whole section describing the purpose and process of delivering a policy statement. That was the only way I was able to understand what they are. And so I can't imagine that the public following this proceeding, but not the sites proceeding, would have had adequate notice or information about the chance to participate here as a non-party. And so I would request that the hearings office possibly reissue an amended notice or a new notice with clarification for the public describing the function of policy statements. And I would also request that the deadline for notices of intent to either appear or to submit a written policy statement, whichever group that deadline was intended for, be vacated and deferred to no sooner than January 20th, 2025, which is consonant with DWR's recent deadline extension. I don't think that extension would prejudice any of the parties because policy statements involve one-off appearances that serve a limited and non-evidentiary purpose. Thank you.
Thank you, Ms. Bear, and that's well taken. I hadn't, it's a quite helpful note that there may be language in some of the sites proceedings that notices that would be helpful here that maybe were not included. Just for clarity, and I appreciate you bringing this up, and hopefully others can transmit this information. And for those who are listening, the deadline to file a notice of intent to appear with respect to those who would like to either give oral or written, submit written policy statements, that's entirely optional. It is quite helpful because then I can put out a tentative order of proceedings for the February 18th day in which we'll hear policy statements, but other members of the public are welcome to attend and are not required to have announced their intent in advance to provide an oral policy statement. So it is open, it is optional, but it certainly sounds like there may need to be more clarity on the subject. In terms of a deadline for written policy statements, I have not set one, in part because I think it's appropriate. It may be appropriate for members of the public to wait and essentially submit those policy statements at the same time. For example, you might submit a closing brief to wait and review the evidence in the proceeding before articulating a policy statement. And I actually would not prohibit someone from filing a policy statement in advance and then filing a follow-up based on the evidence. Again, these are non-evidentiary statements. They're not subject to cross-examination, the parties making them, but they may be submitted. So that I have not articulated a deadline, but it may also be helpful to say exactly what I said in a written notice so that it is more clear.
Thank you.
Thank you. Mr. Brodsky, I said you had a hand and now you don't.
Well, I was equivocating whether I wanted to say it or not, but I guess I will.
Now I called on you.
So for those of us who are participating in each and every pre-hearing conference, I wonder if it might be possible just to file one notice that says we intend to participate in all upcoming sessions. And
we're done now. This is
okay.
it. This was the last deadline for
okay.
it. It's because we hadn't done, normally in our proceedings, they aren't quite so long in the pre-hearing phase. But this was, we have our party list. We have our interested party, those who chose to file, it's not exclusive, but we have our party list and there's no further culling of parties, if you will, unless someone requests to be removed as a party. So this is it. There will be no more requests for notices of intent to appear.
Okay.
From my perspective. So but thank you. Yes, I'd like to be done with this too. All right. Before we actually haven't, this is quite productive. And now I will actually move to the next on my little agenda is the purpose of this pre-hearing conference, although we've gotten quite a bit done. The November 18th amended hearing notice identified a couple of topics for us to go over. I also wanted to acknowledge that I received pre-hearing conference statements from the Department of Water Resources, state water contractors, Sacramento County et al., California Water Impact Network, Deirdre Desjardins, and Sierra Club et al., Sierra Club California et al. And I wanted to first recognize that I realized there were several requests to postpone this pre-hearing conference, and there may, in other circumstances, it may have been more efficient to do that. I recognize we may not be able to accomplish quite as much as we would in a later date today, but I thought it was important for us to meet and work through as much as we can, and I think already that has proven true. I was hesitant to try to pick a new date in January because we have so many parties and so many schedules, and this had been on the books. So that's just a little background of where I see ourselves going forward. Excuse me, my pages are shuffled. With that, I also wanted to acknowledge that there are outstanding petitions for reconsideration. I think that was some of the basis for asking for an extension of this pre-hearing conference. We have that, well, before I move on, Mr. Cho, I'm sorry, I get into my script and then I don't look up. So Mr. Cho, please.
My apologies. I just wanted to point out, you may not have had a chance to review it, but North Delta did also submit a pre-hearing conference statement that was inadvertently not sent to the AHO, but it is there for your consideration if you are willing to indulge us. Thank you.
Thank you. I appreciate that note. I saw some other things. I think I didn't realize that came in as well. So thank you very much. I was acknowledging the outstanding petitions for reconsideration. There's a December 2nd motion for reconsideration from DWR and a December 6th motion from state water contractors. In my email of December 9th, I set a deadline of the end of the day today for responses to those motions. My intent today is not to address the substantive issues in those motions. I think at least DWR and state water contractors have well articulated those on the papers. And then I will be hearing from any responses from the parties also on the paper. So my intent is to issue a ruling letter based on that. As a note, a procedural note, I did want to, and I imagine this will come up in the filings, but I did want to raise an order that is now on the books, but post water fix. So it may not have been on your radar if that was the last proceeding before the State Water Board, which is Order WR 2022-0087. It is a precedential order from by the State Water Board in which the board ruled that petitions for reconsideration of a procedural ruling by an AHO hearing officer are not authorized by Water Code Section 1122 and generally are not allowed. And there's quite a bit of discussion in that order with respect to the problems with having serial interlocutory appeals. That said, I realize some of the issues raised might, would be helpful to resolve before we get into the meat of this hearing and that type of thing. So I do intend to look at those motions quite carefully. I suspect I won't be responding to them as phrased as a formal petition for reconsideration, but as more of an informal request to the hearing officer to re-examine some of those decisions. But I do want to generally discourage interlocutory appeals of all the procedural rulings in this proceeding, or we'll never get to the end. And there certainly is a chance to petition for reconsideration of all those rulings once we get to a final order and the board has adopted a final order. And that's when the formal process under Water Code Section 1122 would kick in. Following up on the agenda that I had, which is fairly limited, I had noticed a couple of issues to talk about. One was time limits for oral summaries of written testimony. I only plan to talk about time limits for DWR since we haven't even, we're not to the protestants yet. So I wasn't going to look at the larger issue, but the smaller issue, because I does seem helpful to DWR, at least from my perspective, for you to know what the expectations might be, or at least a framework. I think we will defer for today talking about time limits for cross-examination. As some of you noted, it's premature. We haven't seen the testimony. We can return to that on February 18th. But I did at least want to begin the conversation about groupings of parties for cross-examination and get all of you thinking about that, and then order of cross-examination. That's another issue that would be good to address in advance. The third issue was this question of the site visit. I'd like to briefly talk about. And then finally, we'll go to any other issues that may have been raised. So that's my general outline for today. With that, I will turn back to number one, which is oral summaries, time limits for oral summaries of written testimony. And I came up with well, I guess I'll tell you what I'm thinking to Ms. Carroll and the folks from DWR, and then give you a chance to respond. I realize this is a bit of a cold call, if you will. But what I did is I looked at the number of hearing days that we had set aside for DWR's case in chief and considered the number of hours that, I mean, each day is not an 8-hour day. We have breaks and there's often sort of housekeeping that has to happen. But considering the number of hearing hours, and then we actually went back and looked at the site's reservoir proceeding as a model and crunched the numbers and did some data mining there, which may or may not be representative of what will happen in this proceeding, but it's the best we have. And remarkably, the numbers aligned pretty closely that it was right. We're in the range of, when you set aside procedural motions and things like that, I think we're in the range of about 25% of the time is spent on oral summaries of written testimony, which I thought was quite fascinating, actually, that there was a convergence. So I took the time allowed and said about 25%, and came up with roughly 16 hours for DWR to present the oral summaries of the testimony of its witnesses. And I realize hopefully you've identified your witnesses now and are probably working on the testimony, but I wondered if you wanted to respond to that. Of course, there's a chance to ask for more time, but as an initial layout of expectations, do you have any particular response to this 16 hours for DWR to present its case in chief, the summaries of the testimony?
Thank you, Hearing Officer Kinsey. That should be sufficient, especially with the ability to request more time if needed.
And my intent there, I think, as we move down the road, this so-called chess clock approach that we used was helpful, where we just have a general lump of time. And my intent would be, if you use less than 16 hours, you can take it with you, put it in the bank, if you will. And that would be part of how this would work. Are there other comments on this issue of DWR's limits for summaries of written testimony?
Ms. Kinsey, if I could just ask one clarifying question. Does that time exclude the time taken for objections?
I think that's a good question. That's what I was thinking, because we actually, when we crunched the number, if we're going to use and as I said, I appreciated that I could use math to come up with a number. When we crunched numbers, there actually was slightly more than 25% of the time, and I attributed that to objections. So no, it would not include objections, and we could come up with some number in addition to account for that. So no, it would just be the actual summaries of direct testimony.
Thank you for the clarification.
Thank you. Thank you for the question. Ms. Baer.
Yes, this isn't about DWR's amount of time directly, but I just want to raise a related point that the hearing officer has suggested that DWR submit its entire case in chief on the same day that comments on the hearing issues are due. And we're concerned that that timeline effectively renders any comments irrelevant, because there will be no opportunity to revise the hearing issues based on feedback. And so I would like to raise sort of pre-DWR time limits, that we finalize the hearing issues first and shift the timeline to defer case in chief submissions until the full scope of the proceeding is settled, since that's still a contentious issue at this point.
Thank you, Ms. Baer. Let's talk about that a little bit, because I noted that argument, which and I was struck by, because I thought, well, that's an interesting argument on behalf of DWR, which is fine. But I wanted to understand that better. Is the concern? I mean, it is awkward. I'll put that out there. It's the timeline to have the comments on hearing issues. The balancing concern there was I wanted to make sure that protestants had sufficient time to really look at the hearing issues to know I'm going to be involved in this case. These are the hearing issues, and I time to thoughtfully respond to those. That said, there's a counteracting interest in moving forward with this proceeding, and based on my experience in other proceedings, the hearing issues rarely have, fundamental shifts. It's typically a revision of the language within the scope that's already laid out of the outer bounds. That said, I realize there could be some changes that may affect DWR's case in chief. My intent with that would be if there were changes that affected DWR's case in chief and DWR was in the position of saying, look, we would have put this evidence, excuse me, evidence on if we'd known there would be this change in the hearing issue, then DWR could then present that case in chief evidence, that hopefully minimal additional case in chief evidence at the time protestants submitted their case in chief evidence later in the year. And that way we can move forward and start the hearing and then have time to thoughtfully think about those hearing issues and finalize those. The other option was to bump up the deadline for submitting comments on the hearing issues, and I opted not to do that. I thought it was more productive to give protestants the most amount of time possible, but I do acknowledge that it's not ideal. It's
yeah, it's a tough situation. I worry about kind of a leapfrogging situation happening where we finalize the hearing issues and then DWR says they had more evidence they didn't submit, and then they submit it later, and then we don't have time to adequately address that, and then this proceeding is already fairly procedurally jumbled, and I think any opportunity we have to sort things out at the outset to allow us to better prepare our case in chief and sort of level the playing field for all parties, I think should be prioritized. But I know Eric was sure has more to say about that.
Thank you, Ms. Bear. I'll turn Ms. Desjardins. Do you have comments on this issue?
Yes, I do. I did want to say that we had a radical change in the federal administration, and we're at a tipping point potentially for environmental regulations. There's going to be potentially very radical changes to the Environmental Protection Agency, and they're talking about fairly sweeping changes to regulations. So the hearing is proposed to start right in the middle of the first 100 days of the new administration. And reportedly, there are going to be quite a few executive orders rolled out. And so in that, there is an issue. A number of protestants have filed protests that the proposed operations by DWR are very vague. They do rely very strongly on Clean Water Act regulations. And so I just want to raise the issue that it's a very difficult nexus, and it's not just having it due on the same day, but having it within the first 100 days of the new administration. And it's really difficult for anyone at this point to predict what's going to be rolled out. But I wanted to second Tara Bear's concerns. I really think it also has to do, it's very difficult to understand what the scope of testimony would be without seeing, what needs to be raised. And to the extent DWR is planning to produce more evidence about what exactly the planned operations are, what exact constraints, that's really difficult then for protestants. And we did have that issue in the water fix hearing, and it really tied into objections because, and I did get into it some in my brief, but relying on proposed operations that may be remote and speculative is really a due process issue. for all of the beneficial use considerations. So that's all. Thank you very much.
Thank you, Ms. Desjardins. Appreciate it. Mr. Busher.
Yeah, just briefly, a couple of things to add to Ms. Bayer's note. I think she's right. It's really hard to set limits without knowing the full scope of the testimony, and I appreciate that it sounds like DWR is comfortable with 16 hours for however many witnesses they intend to present, but the number of witnesses needed may go way up or down, and that may be a number that then needs to change. And then second, I would say, I mean, I will not profess to have a wealth of experience in a host of water rights issues. And so I don't know whether fundamental shifts are particularly common, but here we've seen a fundamental shift since the petition was filed to today. And for the DTEC and Baykeeper protestants, we have significant concerns with the hearing issues as framed and the scope of the hearing as framed, especially as it relates to the scenario approach. And so there may well be significant comments and pushback or significant changes on those hearing issues as we move forward. And then, you articulated, I think there are two real difficult choices, right? You can not give people less time to comment on the hearing issues or have the deadline between the case in chief evidence and the hearing issues closer or on top of each other. I'll just note there's a third choice, which is that DWR's deadline for case in chief could be postponed until after those hearing issues are raised and after a final determination has been made by the hearing officer as to what the scope of the hearing will be. And last, I will say, right, timing should not be driving substance here. This is, right, a $20+ billion project. This is an important issue for a host of different interests and a host of different parties, as evidenced by, right, the long list of NOIs and requests to present evidence and participate. The substance should be what drives, and figuring out the substance first, and the timing will follow in whatever logic follows. But the substance has to drive the train here.
Thank you, Mr. Busher. And just as a follow-up, because I mean, I can surmise the answer, but it's more fair if I think more appropriate if I ask you. I presume, and correct me if I'm wrong, that if I were to postpone the deadline for DWR to submit their case in chief evidence, that you would correspondingly ask for a postponement in the start of cases in chief.
So I think that the February 18th date would be pretty undoable in terms of presenting evidence if that January 20th deadline moves at all. I think it's probably appropriate to push out those deadlines for case in chief, or those dates for case in chief. I think it may take some time to sort through all of the parties' views and objections to the hearing issues and to make a determination on those. Right. I mean, this is why I think the substance should be the driver of the train. If we pick March 24th or February 18th as the date on which case in chief must start, we create a bunch of conflicts leading up to then that are completely unnecessary if we do the substance right and then land on whatever date we land on after the substance is done.
That's a yes. Yes.
So I think it would be extended. I mean,
if I postpone,
yeah, I think we suggested 30 days in our submission. I don't remember off the top of my head, but and that's going to push the calendar out for the protesting deadlines as well, likely. I don't know. I mean, I think my hesitancy to engage is that I don't think it was necessary to pick a date to start until all this stuff was done. So the idea that that date is now, setting our expectations for how quickly things should move, I think is just misguided in the first place. And I think we should get the substance done, and then whatever date we're at, the hearing will start. And we'll have a better sense of that after January 20th and after a final decision on the hearing dates. So, I mean, we can call it an extension of the March 24th date. I just think it was premature to set that date in the first place.
Thank you, Mr. Busher. I believe I understand your argument. I'm not sure where we are. I'll pick up in a moment, but it looks like we went through the hands. We talked about time for oral summaries of written testimony for DWR. I had already mentioned that we would defer today for cross-examination of witnesses. that issue, the time at least. I would ask for all of you to think about appropriate groupings of parties for purposes of cross-examination and for time limits for cross-examination. I will be following up with an additional procedural ruling. My inclination would be to ask all of you to submit on January 20th proposed groupings and a proposed order of proceeding. In the past, we have followed, for cross-examination, we've just followed the order in which parties presented their case in chief. That's not, we don't have to do it that way, especially here, where you may not have sorted out appropriate ordering for the protestants to structure their presentation of cases in chief. But if there is a proposal, I certainly would appreciate that. In general, we would hear from DWR, and then well, I think you should tell me what would be appropriate, and I would strongly encourage all of you to talk to each other. I can make a decision if I need to, but I think it's better when there's a proposal from discussion with one another. Ms. Tabor, did you want to chime in on this issue?
Yes, thank you, Hearing Officer Kinsey. My initial reaction to your proposal is that I think it would be very challenging for my parties to come up with proposed groupings and before we've seen all of DWR's testimony and had a chance to consider that and confer with similarly situated parties. So not only would it be probably not very productive for us to try to do that by January 20th, but that there just isn't much time between now and then, and all of the protestants in this proceeding have so many other commitments that it would make sort of productive conferring with them very challenging for us. So I would suggest that grouping not be, I agree with Mr. Busher that the March deadline should not be driving all of these other issues, but that at a minimum, we not have to submit proposed groupings until we've had at least a month to look at the DWR testimony. Thank you.
Thank you. And your point's well taken about seeing the testimony. Noted. Thank you, Ms. Tabor. Mr. Wright.
Yes, thank you. In the water fix hearing, the hearing was divided into two parts: the water rights, then followed by public interest and environmental. That seems to make tremendous sense, and it avoids the waste and inefficiency of the possibility of maybe having a water rights presentation one day and the next day public interest and environment. It would avoid the burdens on both the water rights protestants on the one hand and the burdens on the public interest and environmental protestants on the other hand, to have to basically monitor or even be present throughout an entire lengthy proceeding instead of just the portion in which they're participating. I know we raised that in our written statement, and I know other people have raised it in the past. I know you want to, we all probably want to speed things along today, so I'll just leave it with saying that.
Thank you, Mr. Wright. And I will just reflect back so that if there's any interest in continuing to respond, my perception of the water fix proceeding is that this division did not work very well because there was so much overlap, and that the hearing team ended up spending a lot of time attempting to police the division, if you will, for fairness reasons. That said, it certainly is in our best interest to structure this so that if there are certain days where certain parties don't need to participate or wouldn't, there are different issues. I would like to make this as efficient as possible for everyone and try to sort that out in advance. So it may be through scheduling, we could identify those days in which certain issues would be a topic for testimony. But just to alert you, in general, my inclination was not to do this type of phasing by subject matter because it was so difficult from my point of view. And you're welcome to, sounds like from others, it may not have been, but it was so difficult to monitor. and that we're better off bringing the testimony in as case in chief rebuttal with respect to all subject matters, which doesn't mean we can't, as I said, sort it out to some extent by hearing day, and then have certain hearing days where certain issues are heard. Ms. Carroll, would you like to jump in on any of these matters?
Apologies, I'm trying to deal with my technology. Yes, no, we would agree with you that the phasing in the water fix hearing was particularly difficult, and we would appreciate not repeating that process. Also, with respect to the groupings, I mean, we've already received all of the protests from the parties, and we can see the issues that they've raised. They've also already filed protests in particular groups, which would help with the groupings and the proceeding going forward. So, I mean, I don't think DWR will be putting forward its own proposal as to how we believe the parties should be grouped, and hope that they coordinate with each other. But that's our opinion on how the hearing should proceed on this.
Thank you, Ms. Carroll. Mr. Moore, I believe you're next.
Yeah, I just want to briefly weigh in on what Mr. Buescher and Ms. Tabor and perhaps others have noted regarding, the need for the hearings to fit the issues and matters at hand here in light of the circumstances, rather than being driven by some kind of general sense that this has to move along. And to that end, I just want to point to one of the submissions. Seawin was among the protestants that were part of the joint pre-hearing conference statement that quite a number of the protestants submitted for today. And I just wanted to point you to, I believe it was Exhibit B to that pre-hearing conference statement, provides what I think is a very useful run through of where things are in DCP related review, permitting, finance, and other matters. When you look at it, I think what emerges is quite clear that for any number of reasons, the matter is not really ready for prime time, and there is no basis to cut corners here or not allow for a fair consideration of issues based simply on a general sense that this matter has to move along at the first possible time. I do understand that efficiency is an important consideration, but proceeding prematurely on some of these things may end up proving counterproductive because of the adjustments that would need to be made later.
Thank you, Mr. Moore. Ms. Desjardins.
Yeah, I did extensive cross-examination in the water fix hearing of most parties' experts to try and clarify the technical issues that were being raised. And one of the key issues was that the proposed operations for the project were changing during the hearing, and in ways that weren't made transparent to the other protestants. Remember, I think it was Sacramento County had a subpoena for, I believe it was the incidental take permit operations, and it wasn't provided until the end of part one. And so that was an enormous burden on the protestants, that the settlements were occurring during, Contra Costa Water District, there was an agreement and to provide a new diversion point for them. And so having the project itself and the proposed operations changing during the hearing it resulted in huge amounts of inefficiencies. And I think that wasn't so much that the hearing was in two parts, but that the project itself was changing in ways. And it's fundamentally necessary to have the project adequately defined. It also led to a great number of objections that the hearing officers had to consider. And there were petitions for reconsideration, and it was simply that the project operations relied on regulations that were changing and things that even the Department of Water Resources knew were likely to change. I did provide some evidence in my letter of pre-hearing conference issues about one thing where we know the water quality control plan constraints. There's plans to change them for climate change. And this is exactly what the Delta Reform Act was meant to address, was the appropriate delta flow criteria. And it's a real problem that you have this huge project that's meant to deal with climate change, and we don't really know what the preliminary operations are. So it's really would help efficiency from my viewpoint, and also help with narrowing the technical issues and knowing, you know, and making cross-examination easier if things are adequately defined. And some of these issues can be resolved, and it will be much more efficient and much less frustrating for both the hearing officer and the parties. So I did want to give that as my recommendation.
Thank you, Ms. Desjardins. Ms. Carroll.
Thank you, Hearing Officer Kinsey. I'd just like to highlight that, you know, DWR submitted its petition for this project, and pursuant to requests and prior to our case in chief, we've also submitted an operations plan, and we also have a final EIR. It's very clear what we're seeking. The statute, you know, sets forth the issues and the standards that apply to this hearing. It's not a secret of what's going on. And also, this is not water fix. I mean, I know there are lessons to be learned from the hearing process, but this project is completely different, and the issues that appeared in that hearing are not going to happen here. So I just want to reiterate that we should really focus on the project at hand and the standards that we're held to.
Thank you, Ms. Carroll. And since I have you, can you remind me, I believe the last time we spoke, there was an expectation that an ITP would be forthcoming soon. Am I remembering that correctly? And is that on the street, if you will?
I wish I could say it was on the street, but we do expect it by the end of the year.
Okay, thank you. Ms. Meserve.
Thank you, Hearing Officer Kinsey. Just to address this was discussed in the December 9th joint pre-hearing conference statement a little bit in the context of the questions that the hearing officer had regarding the amount that the water rights had been perfected. But, you know, pointing to the operations plan to me I don't think it is that much different than what we saw in WaterFix, and I don't want to get bogged down by WaterFix. I agree with Ms. Carroll. We need to focus on what the project being proposed right now, but 2 places in the operations plan says this is a living document. It's just an example of how DWR might operate. Now, DWR could propose now, or in its case in chief, to say it intends to operate how it's described, you know, in the modeling in the EIR, for instance. Some projects have been required by the Water Board to operate within the parameters that they've presented in modeling. And that can be a way to avoid the problem that we have here, where there's an example of operations being provided, but there is no certainty regarding what the operations in the future may be. So I think that's something that is going to be kind of an Achilles heel of this hearing as we go forward. We can certainly look at the information that DWR presents in its case in chief about what its proposed operations are, but unless it says, you know, this is how we're going to do it, And it's a pretty narrow spectrum, and it's not subject to, complete change in the future, especially with, federal limitations on pumping water being a bit in question at this point. So yeah, that's all I want to say for now. Thanks.
Thank you, Ms. Meserve. Ms. Desjardins.
I just had one follow-up. So there is a relevant case which I did raise repeatedly, but regarding the kind of evidence which you even admit under the evidence code 801 to 805, which do govern water board hearings, Sargon Pharmaceuticals versus University of California is the leading case, and DWR itself raised the issue about the hearing officer should consider what evidence is even admissible. And under that standard, evidence that's based on substance which is too remote or speculative shouldn't even be admitted. And that's the problem with modeling that's based on a scenario, a what if scenario, rather than an appropriate range of operations that one might actually see. And it's something that is absolutely foundational to this proceeding and to, again, to the beneficial uses, to just have a hearing on it based on modeling, which is just speculative operations. We have seen the project operated basically the permit.
Ms. Desjardins, you went on mute, it looks like.
That's really a key issue. So that's all I wanted to say. Thank you very much.
Thank you. Ms. Carroll.
Thank you. I just wanted to address that, yes, the operations plan by nature has to be a living document because of the regulatory requirements that DWR is held to. So, we do have to go and abide by our permits. So that's the intention of the living document, is to ensure that we are operating appropriately.
Thank you, Ms. Carroll. And thank you for all of your comments on this group of issues. What is coming to my mind from this discussion is we will know more when we see the case in chief evidence. We will know more about whether there's a mismatch between the evidence and the finalized hearing issues. We will know more about the nature of that evidence. We will know more about groupings and ordering and cross-examination. So this is reinforcing to me the importance of having an additional procedural discussion, an opportunity to submit what effectively would be pre-hearing conference statements, except we will have started the hearing, so I don't know what we call them. Hearing statements that address procedural issues. I had been envisioning that February 18th would be an opportunity to do both, to both hear policy statements and address any remaining procedural issues. It's looking more and more like we may have a chunk of procedural issues. So now I'm considering whether we need another day, just to make sure we have enough time. It may actually introduce flexibility if there are interested persons who can't make the February 18th day for policy statements, and then we could have another day on the books as well. So that may be appropriate. We don't need to just, I'll put something out there. I mean, at least we're speaking well in advance. But it would be in the range. I don't know if it would be the 18th is a Tuesday. Wednesday is a board meeting, so that is not a good day, the 19th. And we have other matters going other days. So it may be that we end up with the 19th or the 20th of February. But it does seem to me that we may have a bulk of procedural issues that just to make sure we get back to it and take a look that we're proceeding in an orderly manner, and we will know more at that point. You will have had a chance to look at DWR's evidence to some extent, and we can proceed from there. Is there any, Ms. Carroll, please?
Thank you, Hearing Officer Kinsey. I was going to say, would it help you if we submitted our availability for that week? And we could look at what would work for the majority or those who would like to participate on those days?
Yes, although what I can tell you is that we currently have a proceeding in the site's reservoir matter on Friday. And there's a board meeting on Wednesday. So and the site's reservoir proceeding continues the next week. So we are limited. It may be that we need to look out a little bit further. But if the parties could coordinate amongst yourselves and discuss a possible additional day that we can use either for remaining policies, probably remaining policy statements and remaining procedural matters that we aren't able to address on February 18th, and submit that to the AHO, ideally by the end of the year. Let's put it that way. And we can get something out. Ms. Carroll, a follow-up.
Yes, would you be open to dates the week prior to the 18th?
Yes, I think we could do that. I'm trying to think whether there are any problems with that, but no, I think that would be fine. Looking the week prior could work.
Thank you.
Take a look at the site's reservoir hearing schedule.
So Ms. Kinsey, this is Eric Busher for Baker. I am certainly not going to disagree that we're going to need another day to sort out a bunch of these things, and maybe more than another day on the procedural and scope side. If that's the reality, I think the best way to do it is to use the day we've already got on calendar, given the site's hearings that are going on through January, February, March. And then, we've got between this one and that one, more than one water board hearing or water board proceeding most days or most weeks in that kind of mid-January through mid-March timeframe. Adding a day to that is not a tenable solution, especially given the overlap between the parties, especially on the NGO and tribal side, where, showing up for 40 of these is a huge commitment in and of itself, and adding on to that is, I think, unwise, given that we've got a date scheduled where we could set aside and try and work through some of these issues before the evidence actually begins.
So just to make sure I understand, Mr. Busher, your proposal would be to postpone policy statements and use the February 18th as our entirely for procedure.
If we're stuck with the March starting evidence in March, yeah, rather than adding more days between now and March to an already overwhelmed calendar, let's do it on the date we've set aside. And especially given your comments about the policy statements as well, those are non-evidentiary. I appreciate that having kind of a fixed target for the public to shoot for, to be able to show up is valuable, so that everybody can know this is the day I need to be there and they don't have to wait and guess. But there's no reason that needs to happen on February 18th as opposed to one of the other days in March or later in the proceeding or some other time. And that would be my suggestion, is to use the date we have rather than try to create a new one.
Thank you. That's helpful. Mr. Moore.
Just adding a little to what Mr. Busher just mentioned, obviously the protestants haven't had an opportunity yet to coordinate on all of the specifics, but my understanding is that there are at least a couple and likely multiple conflicts associated with attempting to find an earlier date before the 18th. So it will take a little time to sort out if there is even an available date, but it maybe underscores the point that Mr. Busher just raised.
Thank you. And it is well taken. We could move the day for policy statements or days, and that may be a solution here. Are there others who would like to comment on this issue? Mr. Wright, please.
Yes, and picking up a little bit from what Deirdre Desjardins and Eric Busher and Roger Moore said at various times earlier in the same discussion, it would seem, again, by making the most adhering to dates, it would be difficult to start a proceeding with more certainty.
I'm sorry, Mr. Wright, it may just be me, but you're cutting out a little bit. Your microphone is cutting out. Look to the court reporter. Are you having a similar issue?
Yes, thank you.
Okay, thank you. Mr. Wright, if you can maybe, and I mean this very politely, get close to the mic and stop moving may help. It seems to be associated. Please go ahead.
Is this better?
It seems to be, yes. Thank you.
Okay, thank you. It seems it would be difficult with the dates being set to create more uncertainty. As was pointed out earlier, all we know is that the federal standards are going to change. The Environmental Protection Agency, National Marine Fisheries Service, U.S. Fish and Wildlife Service are not going to be issuing the same types of opinions, for example, in the new administration that they did previously. And at the same time, we don't know what the updated water board standards are going to be. It just seems like it would make much more efficient and quicker proceeding if the evidentiary part started when we knew what the updated Bay Delta plan is going to be. And also we would have seen the executive orders coming out from the new federal administration in January. A thought I had, it's not as bad as, but one could picture a teacher telling students to write a book report, but the students didn't know what book they were supposed to read and review. Anyway, that's all I have to add. Thank you.
Thank you, Mr. Wright. Ms. Carroll.
I just wanted to remind everyone that the ITP, the incidental tank permit, is issued by a state agency, the California Department of Fish and Wildlife. And that although the Bureau is participating here in this hearing, it's not based on the federal regulatory requirements necessarily. And I believe it's more to ensure our coordinated operations of our projects.
Thank you. Ms. Desjardins, although if you can keep it brief, I think you've had a lot of.
Yeah, very briefly, I did include some briefing on the coordinated operations agreement. But there was a fundamental issue when the reclamations permit was issued. It assumed the entire unimpaired flow of the Feather River. And they did work out the coordinated operations agreement. There's a major change to that in 2018, and there's now no longer an agreement in a third dry or critically dry year. And also the existing COA could be terminated by either party with 180 days notice. So it is absolutely fundamental that DWR's water right, because the initial permits, the work showing that the studies showing that water was available for export for reclamations permits assume the entire unimpaired flow of the Feather River. And this is a core conflict that hasn't been worked out, and it does relate to the protestants' argument about DWR's time to complete the project.
Thank you, Ms. Desjardins. Mr. Wright, I'm assuming this is it's a residual hand that you have up.
I'm sorry.
Do you want to chime back in? You still have a Zoom hand up, and I thought maybe it was residual.
Yes, it's just residual. No,
okay, thank you.
Thank you.
This is all quite helpful. on my list of things to discuss, I have us moving to the question of a site visit, which is another creature in and of itself. But before we move that way, are there any others who would like to chime in on what we've discussed so far? Mr. Krieger.
Yeah, thanks, Hearing Officer Kenzie. I just have a question, and we raised this in our pre-hearing conference statement about the timing of the submittal of cases in chief for entities that are now parties as of last Friday, including the state water contractors. I recognize that there are, certain issues that are still sort of up in the air for discussion. And I wanted to know, just as a general matter, if the hearing officer was thinking that the timing of those cases in chief would essentially align with those of protestants at this point, or if there's value in having a more specific conversation around that at this time, or if that's something we should maybe pick up a little later. Thank you.
Thank you, Mr. Krieger. Others may very well have comments on this, so let's talk about it. My intent was to have those submitted with the protestants case in chief later. Although there's an alignment with DWR, the purpose, I think, was to move forward with, because DWR will have a substantial portion of the presentation of evidence to get started and move forward with that. And then we can pick up later with protestants and others who are not the petitioner, and that we would have those run together. That was what I was thinking, but I would invite further comment on that. Mr. Busher, I realize your comment may not be on that particular issue, but please chime in on anything we've discussed so far.
So, I think Mr. Krieger's question is an excellent one, and I'm not sure what my answer is. It seems odd to have people who are on DWR's side of the V, so to speak, not presenting at the same time as DWR, I guess. But I don't know. I think that is something that we need to figure out as part of case in chief order and cross-examination order as to how, the Bureau or the state water contractor's involvement goes. I'll let others speak to this. I have a separate question, but I can wait to come back to it.
Okay, thank you. Mr. Brodsky, was your comment also on something else, or would you like to address the?
It was on sort of what we've covered so far. I had the sense we were going to close the door and move on to something else, so I wanted to jump in. Just respond briefly to Miss Carroll's statement, and also as to why this is so complicated is because the application, like WaterFix, the application is incomplete. Section 1260C says the application should have the nature and amount of the proposed diversion. We don't know what the amount is because we're now heading towards two alternative scenarios. One, if it's the full permit amounts, in other words, if the 50-year extension is granted, or alternatively, two, it's only the amount of those permits that's been developed so far, but DWR doesn't want to tell us what that amount is. And so now the attempt is to push that off now further, not to provide the information as you had ordered, but that'll be developed through direct testimony and cross-examination. And that's exactly what we did in WaterFix. So I felt compelled to make that observation. The other thing that I was going to comment about, and if you don't want to do it today, that's fine, was on time limits on cross-examination. I don't feel you can put a strict numerical time limit on cross-examination, regardless, without seeing the content of the testimony. May I say a word about that, or is that just something you don't want to hear today?
Well, you're welcome to, with the caveat that I think I agree with you, which is it makes sense to see what DWR submits and then talk about what appropriate time limits would be for cross-examination of their witnesses.
Well, I think regardless of what the actual testimony is, and a little bit of dose of legal realism here. So this testimony of DWR is in large measure going to be highly technical, scientific, engineering, hydrology, and so forth. And, the way the game is played is that their experts try to evade making admissions. So you, as a cross-examiner, ask a question, isn't it true that X? And they don't want to answer that question, so they dance around it and they use up time. And if you have a hard numerical limit, that invites that kind of behavior and to just run out the clock. And so I think in terms of cross-examination in this kind of a highly technical proceeding, certainly we want efficiency. We want to do things like the cross-examiner should, be prepared to say at the outset, here are the subjects I'm going to cover. Here's how much time that I think each subject will take. And then the LJ at that point can say, well, wait a minute, this thing over here was already covered. You don't need to do that again today. And those sorts of things, can be done to try to make cross-examination more efficient. But I don't think you can put a specific hard numerical time limit on a cross-examination, or just incentivizes the expert witness to evade answering the question, evade making the admission, and run out the clock.
Thank you, Mr. Brodsky. I agree it's a difficult issue, and I'm not going to make any decisions on it today. I have found that time limits are quite helpful for moving things along. As you know, there are more or less effective cross-examiners, and certainly to the extent that a cross-examination, a line of questioning is productive, or that the witness is particularly difficult to move along. I understand that, and that would be the appropriate opportunity for more time. I believe it will be my intent to have some kind of guidelines on limits so that we have check-in points to say how much more do you have, and we go from there. But
I agree with all that.
Yeah.
It's just that I would want to avoid a situation where you have 25 minutes for this witness, and the witness is eating up 20 minutes, just dancing around, and then your time's up. And you can't get the admission out of that witness that, by rights, they should be made to make that admission.
Understood. Thank you, Mr. Brodsky. Before we turn back to Mr. Busher, I think you reserved you reserved some comments. Is there anything else on this question of presentations of cases in chief by, I don't know what the appropriate parties that are somewhat aligned with DWR? And we can turn back to that, but I think now, Mr. Busher, if you had other comments or questions, let's move to those.
Yeah, so just before we move to the site visit, I want to second Ms. Tabor's request that whatever protesting groups are asked to submit about order of cross-examination be postponed until after we have DWR's evidence for the case in chief. And then note there on that same subject, I don't want to, I think it would be difficult to fix that order in stone, that, the tribes are always going to be first, or the counties are always going to be first, or the water agencies are always going to be first in that order, because the different interests, I think the most efficient way to do it is to find the people with the kind of whose protesting client has the best interest, let them lead the cross-examination, right? And that may be different for different issues. The other question I had, you mentioned the deadline for oppositions to the petitions for reconsideration from DWR and the state water contractors. And I took your description of that and your reference to the 2022 water rights decision, that's not really a formal petition for reconsideration because that's not available in this context under the state board's rulings. We addressed several of the issues related to those petitions for reconsideration in our pre-hearing conference statement. It seems sort of redundant to resubmit those, especially given the lack of formalism on, petition opposition. And we would just ask that those be considered, right? Those pre-hearing conference statements addressing those same subjects be considered in the hearing officer's evaluation of the request, because candidly, I'm not going to have time to draft a new opposition that says those same things today, to have that submitted. And if that's not available, we would ask for, an extension of that time. And I'd rather just have it be considered since it's already been submitted than to ask for more delays on that ground.
Thank you, Mr. Busher, and that's certainly fine. And I will attempt to remember, and I'm putting a note down in any ruling to clarify in writing so that we have it for whoever may care later, that the pre-hearing conference statements will be considered to the extent they're relevant in response to the petitions for reconsideration. So that's clear. So, thank you. That makes sense.
Thank you.
Mr. Brodsky, did you have something else to add, or is it a residual hand?
I'm sorry, I forgot to take it down.
That's okay, thank you. Before we move to the site visit discussion, are there any other comments on matters we've already discussed? All right, moving to the site visit. From reading the pre-hearing conference statements, it seems that there is a general concern from DWR and others in that general alignment about the logistical challenges of any such site visit, which I can certainly understand. And then there also was a strong request, as I understood it, from some of the other protesting parties to conduct a site visit. There are a number of options. We did conduct a site visit in the site's reservoir proceeding. It was logistically challenging, and I think I committed to myself that we would start this process sooner if we were going to do it in this proceeding. We have an entire proceeding, so I think it sounded like now I don't recall which statement, but if we were to do some such site visit, there may be benefits to not doing it in the winter or early spring, but waiting until after. I think the comment was April. So I think we have time if we are going to do one, we have time to discuss when it should be conducted. I understand that there are challenges to access to private property that may be involved in the project, but we don't. The petitioner does not yet have access to. But I wanted to be open to the possibilities. There are a couple different ways we could conduct a site visit. One question that really, I think, affects the potential impact of a site visit is whether a quorum of the board members may be present. If they are present, then it is a public meeting and we need to notice it as such, and the public would have to have the opportunity to attend. If we did not have a quorum present, I think we could fairly, and I would consider whether to limit participants to hearing parties and their representatives. And we could proceed in that way, and at least we'd have some greater certainty about the number of people who may be involved. So I don't think we're going to, I know, we're not going to resolve this today. What I would propose is, it sounds like right along with cross-exam time and ordering and all those things to put this together as something to think about, particularly for those of you who are proposing that there be a site visit. What would that, very specifically, when? Logistically, how would it work? What types of locations? I'm not asking for commitment at this early part of the proceeding, but what sites you would propose to visit? How would you obtain access? Is it possible, essentially? Because really I'm dependent on you all of you as protestants or petitioner, to work out the logistical details of how we might visit or access each point. So this is not a decision we are doing one or we are not, but if there are those who are supporting conducting a site visit, I'm asking you to put together a proposal, a concrete proposal, and then we can discuss that in more detail. Ms. Carroll, please.
Thank you. I just wanted to remind everyone that we have proposed a virtual site visit that we are still willing to conduct for all of you that would be available after January 1st. That may also preclude the need after seeing that virtual visit for having a physical site visit with all the difficulties.
Thank you, Ms. Carroll, and I did note that in your conference statement. So thank you for that. Ms. Meserve.
Thank you. Yeah, we did put in our joint statement from December 9th, a preliminary list of locations that we thought would be important for a site visit. Those include on land and in water. We also include a map of the entire area. So yeah, just because of the winter, it's very muddy. However, the sandhill cranes are in the Delta over the winter. So anyone who wants to should go to Staten Island or Woodbridge or Casumnes and look at those this winter. It's very easy and fun, and they're large and don't move fast. So you can get a good look. Yeah, I mean, I think for my clients as well as others, it's really important to see the site. And I don't think that it's an excuse to say, oh, we're going to impact a site that's so large that we can't show it to you. I think that just underlines the need for the hearing officer, staff, the rest of the parties to be able to see what is going on. And there's a full range of impacts on water rights as well as on public interest topics. So, having spent a lot of time in the Delta and done a lot of tours, we have tour itineraries where we've taken congressionals and state legislators and water board members and anybody and everybody. So, we have a good idea about how to do this. It does take about 2 days probably. It requires some arm twisting, to try to find a boat that we could put people on. But, I'd have to see if there were other petitioner reps and others that would be willing to help. I was hoping that DWR would be interested in making sure that, for full disclosure, there's a real sense of what the site is. So it would be much easier to do with the cooperation of DWR. So, maybe there's a way that the position could change. And I have preliminarily reached out to, I work with the owners of the land at the 2 intakes as well as at the northern launch shaft. I haven't had a chance to speak with Mr. Nomalini about the southern launch shaft, but I assume that he could work that out. A lot of the places for the intakes on the river, you don't necessarily have to go down onto the land because of the levee road being up. You can see from the pullout and, it does probably require a bus though. We couldn't do it like was done for sites with a large caravan. It might be possible for certain sites or certain parts of it, but parking and safety on the levee roads is difficult. And so it would have to be a bit more organized, but I do think it would really benefit the hearing. And it could, like, as you suggested, Hearing Officer Kenzie, it doesn't need to happen right away. So our proposal was to create like a working group, kind of like was a little bit organically formed, I think, in the sites proceeding to, push this forward, come up with some more specifics and proposals for your consideration. Thanks.
Thank you. Thank you, Ms. Meserve, very much for your careful consideration of this. It sounds like you've highlighted some of the logistical concerns that I have, are things like getting a boat. And I can understand that many of these sites, from the waterway is the most convenient way to view the particular whatever it is. But that raises new things. And then also dealing with, as you pointed out, these narrow levee roads that where a caravan isn't appropriate. So I appreciate that. And I understand that if there's a working group that could work through some of these issues, that might be excellent and a way to go. Ms. Bear, please.
Yes, VTech strongly supports the hearing officer and board members conducting a site visit in person, not virtually, to inform your understanding of the project's real world context and impacts. Restore the Delta has done hundreds of these Delta tours, has regular access to the necessary locations, and would propose April or May for the outing. And they, along with other DTEC parties, are happy to coordinate with others. We want to emphasize that the visit should cover several days, and the itinerary should include, at a minimum, a day visiting tribal ancestral lands in the area to understand the cultural, environmental, and resource implications of the tunnel, followed by a day touring waterway adjacent disadvantaged communities to examine environmental justice and public health concerns. Tribal and environmental interests in this proceeding are very place-based, and I will also note that for tribes, there may be sensitivity in setting forth specific locations in writing, but we'll do our best to work with that. And then after that, an optional 1 to 2 days could also be reserved for DWR if they want to highlight areas that they view as important, understanding the project's feasibility. And now I would like to also invite Gloria Alonso from Little Manila Rising to discuss the site visit issue from a community-based organization perspective.
Thank you. Please, Ms. Alonso.
Hello, everyone. I'm just here today to stress the importance, as Tara already mentioned, of a site visit to fully understand the implications of this project in the Delta Seeing both the urban and the rural areas firsthand will provide invaluable insights into what's at stake. It will also be critical to deliver the attention these places deserve, to contextualize the equity-related questions that will mark the future of the Delta communities. Moreover, participating in a comprehensive on-the-ground presentation is necessary to understand these local socio-environmental concerns firsthand and how we anticipate the project impacting other water users throughout the scope of the project. Similarly, in the rural Delta areas like Hood and Cortland, that are not that far away from Stockton, actually within like an hour distance, travel by vehicle will be directly impacted by the project's infrastructure. The Cortland intake site next to a historic farming family is a stark example of the challenges these communities face. Traffic increases, road degradation, and economic impacts, to say the least. These human impacts need to be seen up close to be truly understood. We believe it's critical for the hearing officer to allow us to organize this tour. We can offer a perspective that goes beyond what is typically included in DWR's tours, providing situational awareness that makes these impacts graspable. As described in the pre-hearing statement for the third pre-hearing conference, for today's pre-hearing conference, submitted by the Yale Clinic, one site visit day should be reserved for a tour of tribal ancestral lands to help the hearing officer understand the relationship between the tribes and the project area, as well as its implications for tribal lands, interest, and cultural resources. The agenda for this portion should also be set by the Protestant tribes, and another site visit day should focus on the disadvantaged communities along the Delta's waterways to explore the project's consistency with environmental justice policies and its public impacts. All of that, it's already referenced in the document that the Yale Clinic submitted, which pretty much summarizes what Tara just described. And just to finalize, a site visit as a former community member and somebody who has family in South Stockton should be guided by community experts who have led numerous tours, such as Restorative Delta and Little Manila Rising, to name a few. I think just to say it again, I think it's vital, and it will be really I think it's right to say it. It will be really reluctant and to say the least, it will continue the neglect of marginalized communities if we don't proceed this way. They will help us and help the AHO have informed decisions for what the current state of both urban and rural communities are. And I just think it's summarized and perfectly there, right? There are so many decisions that are yet to be made, but not having a hearing officer with an adequate time frame and adequate preparation will hinder our decision-making process and how we're able to truly contextualize what's happening in these communities. So yeah, that's all I have to say. Thank you very much for the space. I'll pass it back to you.
Thank you, Ms. Alonso Cruz. And thank you, Ms. Bear. Mr. Cho.
Thank you. North Delta would just like to add its support to those who've voiced support for an in-person site visit, particularly given the hearing officer's previous statements. I believe you mentioned that you haven't had much of an in-depth exposure to those portions of the Delta, which we believe would be extremely important for understanding the scope and the scale of the project and its impacts. And these are things that a virtual tour likely would not be able to convey as effectively. As one further point regarding the timing, in full recognition that we may want to have as nice weather as we can possibly get, I believe that there's some argument for trying to schedule a site visit prior to the first date of DWR's case in chief presentation, so that parties have that context to understand as the DWR witnesses are presenting their panels.
Thank you, Mr. Cho. And there may be we'll see how this develops, but if we do conduct a site visit, it may be that it makes sense to do it in parts, depending especially if it's going to be multiple days anyway, that may make sense. So that's another possibility. Mr. Reese.
Yes, Central and South Delta very much support a site visit. It's going to be complicated. It seems like it's going to be multiple days based on just what occurred with sites. By and large, in most circumstances, we can provide access from the land. Most landowners will be willing, but it's going to have to be highly coordinated because we do have limitations on a lot of the levee roads. But I see this as important, but something that's going to take a long time. And if it could be done prior to, at least prior to the commencement of cross-examination, I think it would help a lot of parties with context and make cross much more efficient. But we really can't get out there safely until we get into spring.
Thank you. And I did mean to follow up. I personally have never done one of the Delta tours. It hasn't, for whatever reason, it hasn't happened to me yet. I certainly would have liked to, but it hasn't come up. So that gives some sense of, I mean, I've traveled in the Delta on personal time, but not on a formal tour or by boat. Ms. Desjardins. Looks like you're on mute.
Thank you. Sorry. The impact of the intakes is a huge issue, and it might help if the Department of Water Resources actually marked with, stakes the location of the intakes on the bank so that parties could actually visit and see the specific location, how long they are, how close they are to the town of Hood, and really visualize the size of them. I think it's one of the major hearing issues, and whether there were alternative locations that could have been less impactful on the town of Hood is a major public interest consideration.
Thank you. Mr. Brodsky.
Yes, I'd like to speak in favor of a site visit also. I don't know, with one option might be board members, but less than a quorum, so that you don't run into Brown Act problems, might be something to consider as one of the options. I think, the majority of the actual hearings are going to be conducted virtually, which is something I don't really agree with, but I think I'm fighting a losing battle on that one. But then when we get down to actually understanding the physical setting, at least that we ought to be able to do in person and not do virtually.
Thank you, Mr. Brodsky. And you raise an important point, which is the virtual nature of the remainder of or the majority of the hearing, or more than the majority. We went through this to some extent in the site's reservoir proceeding, and we had some in-person days for, well, I think one in-person day for presentation of evidence, and then it was inconvenient for everybody involved to have additional days in person. I'm certainly open to holding some of these days in person. The policy statement day will be a hybrid format. And by in person, I mean in a hybrid format. So there would always be the option for remote participation. I am certainly open to having other days of this hearing where I sit in person. A quorum of the board members may choose to participate if we are in person. And that's something you certainly can request, and we just need time to plan for it because we need time to plan for space and then all the appropriate notices. But if there are particular witnesses or days in which you or the party you represent would like to be in person, let's talk about that. That's certainly a possibility. So our default is virtual, but we can certainly discuss having in-person hybrid format days.
Okay, good to know. Thank you very much for that.
Thank you. So as I mentioned, the site visit sounds like we certainly weren't going to come to some conclusion. There seems to be a good basis for discussion. I encourage all of you to talk to each other, especially those who are in favor of a site visit, but also, if possible, to work with DWR if there's an opportunity to access certain points or locations that are maybe relevant and important to the project, and continue to have those discussions as we gear up. And again, we don't need to do this. I can understand there's some argument for seeing certain things before we begin case in chief. That said, sometimes it's just as well to see it later on. So we'll just have to see how this plays out, but let's certainly revisit this issue when we talk again on February 18th. And I will ask for pre-hearing conference statements in advance, or whatever we call it, hearing conference statements in advance of our February 18th meeting. And this will be one of the issues to address among many. This is
Kinsey.
Yes, please.
Sorry to interrupt. When you say issues to address in that statement, I mean, is that an expectation that anybody who wants to lead a site visit should have put together a proposed agenda and timing for that by that time? And right, to the extent we can coordinate, great. But it sounds like we've probably got, I don't know, 4 days plus whatever DWR intends to do worth of people proposing site visits. And there may be some overlap there, but as I hear it, I think it's designed to cover different things, even if you may be at the same location for some of those things. So is that your expectation, that we get that far down the road by February 11th or 10th or whenever those submissions are going to come in?
No. And thank you for that clarity. What my expectation would be an update to say for example, we have a working group. We've had these conversations. We've identified this list, but these are certain areas where we're still in discussion. And so it would be really a report of what the state of the current discussions are, understanding that you're under a lot of obligations to do a lot of things. So I would be looking for more of a status report and not a final. I'm not going to say, well, you're not ready and you don't have a itinerary, so we're not doing it. It would be more of a report. As I said, I see this as we have the entirety of the hearing process. There may be certain benefits to conducting a site visit sooner rather than later, but we do have the entirety of the hearing process to do this if it's something that makes sense and can be put together. Thank you. Ms. Carroll.
Yes, thank you, Hearing Officer Kinsey. I just wanted to clarify if you wanted us to continue working on a virtual option also, or if we are just going to waive that option at this time.
That's up. Well, it's up to you. I don't have a definitive. It is not clear to me that the logistics will work for a site visit, right? That may not be an option. And in that case, if it's helpful to a presentation of your case, which I think it would be, then that may be something. But it may be that's something we could allow for coming in later, after January 20th. So let me phrase it that way, which is to say, I don't consider January 20th to be a hard deadline for putting together a drone tour. If that's something that makes the most sense and we end up doing, I think we could bring that in later. And that would be, we'd set appropriate deadlines for that and a hearing time for that. Does that help?
To some extent, but I believe we're discussing this on February 18th. So would that mean that this tour would potentially even be further out?
Yes, I think so. Yeah. You can reserve your efforts, I guess is what I'm trying to say. Reserve your efforts and we can come back to this.
Sounds good. Thank you.
Thank you. Ms. Desjardins.
Yeah, I just wanted to say that the editing of the site video and the height at which the drone is really changes the presentation. And I've seen a lot of DWR's videos and animations, and they tend to minimize certain community impacts, visual impacts. So it's an equity issue for if the other protestants, whether they have the ability to make their own drone videos or not. So I really would consider the fairness and equity issues. There's a lot of smaller protestants. The Delta communities are very small. They don't necessarily have a lot of funds, and will have a huge impact on the North Delta. Thank you.
Thank you, Ms. Desjardins. Ms. Carroll.
Thank you. I just want to clarify, the use of drones is highly regulated, and there's a lot of difficulty in using those. It's unlikely that those would be part of our virtual. It would more likely be satellite.
Thank you. That's helpful too. I believe this is the part of the hearing where the pre-hearing conference where I say, is there anything else we need to address? I know we have a lot of loose ends. There will be a procedural ruling coming out of this of today, and then probably bound together with a ruling on the petitions for reconsideration. I am strongly leaning towards reserving our February 18th day for process because we do have so much coming out of this, and deferring the policy statements until an appropriate later time. I am going to ask for statements or invite statements in advance of February 18th in writing so that we can consider those before we meet again. We will know more as of January 20th about a lot of things. I'm sure there'll be more questions. But I think we've made a lot of progress today in terms of narrowing down some of the issues. And we're set up to have another big procedural discussion the next time we meet. But Ms. Carroll, what else do we need to address? Or is there something on this?
Yes, thank you. These are specific to January 20th, which is why I would like to ask. We had raised the issue of an FTP site on how to submit our case in chief, and we're hoping to receive direction on the logistics of how to do that.
And this is so typically, and maybe I'm missing, I may have not seen this request, and I apologize. Typically in the AHO proceedings, we will create an FTP site. Now that we have the NOIs, we'll create access credentials for all of the parties who are planning to participate as parties. We will email you your specific credentials, and then you will be able to upload documents to that FTP site. And we will then, the AHO staff will take those and move them over to the public site so that everyone can view them. We usually do that pretty quickly within the day, sometimes within hours of submittal, but that has worked in our other proceedings. And that would be what we would propose to do. But now that we have the NOI, once we have the party list, I think I may actually wait until we get any, I don't want to call them stragglers, but any corrections of errors by the end of the week. And then we just go ahead and submit to our DIT the long ticket, and we'll get that information to you. Does that address your question?
Yes, and I just have a couple of clarifying questions. One is, will the water board be adding our final EIR as an exhibit to the AHO exhibits, or should we include that as part of our submission?
I'm going to look, this is a good question. We are planning to, let me look to my team. Will you clarify for me that we have it? We have it, yes, and we're planning to include it as AHO exhibits. And I'm looking at yes, so we are planning to include that as part of our AHO exhibits. We should have the AHO exhibits up soon so that you won't need to duplicate with numbers, so that you won't need to duplicate some of the large documents that we will have and we anticipate others will be referring to. And so we're trying to just keep it narrowed down, but we'll have an index and we will have those uploaded by the end of the year, is our intent, at least an initial attempt. And we are planning to include the entire EIR.
Excellent, thank you. Exactly what we were hoping for, so we could just use your exhibit numbers.
Right.
Other one that I had was, you noted that you would be trying to move everything to the public site as soon as possible, but should we serve the notice list that we have submitted and that we have done the upload to the FTP site?
That would be helpful, I think, especially in this case where it's just DWR. If you can serve a notice, it certainly is helpful to let the AHO know, and then we know to go in there and find it. I mean, although we have the deadline marked, but if you can notify the service list, that would be excellent. Thank you.
Will do. And then just a final, it's a request, just clarifying, in the procedures it had noted to use pleading paper. We were requesting to just use plain line double-spaced paper in order to limit the number of pages and to make it easier for formatting in submitting our witness testimony. And we wanted to make sure that was acceptable.
Yes, I remember seeing this. I think I understand, which is, so would the line paper include line numbers for the testimony? It would. Yes, then that's fine. And it doesn't have to be, and for all of the parties, it doesn't have to be formal pleading paper, just a way where we can logically identify the page and the line, and that would be great. Thank you.
Excellent. Thank you very much.
Thank you. Ms. Desjardins.
Yes, I did notice, so Reclamation hasn't spoken in this pre-hearing conference. There was an issue in the water fix hearing that none of the federal fish agencies testified, and none of the and CDFW wasn't a witness either. And to the extent that a significant constraints on the future operations come from the incidental take permit or the Endangered Species Act, that was a huge issue. Doug Obeji with NRDC did try to subpoena DWR, subpoena fish agency witnesses, federal. They did not appear. I ended up subpoenaing a fish and wildlife witness who did give some very helpful testimony about the pelagic organism decline. But it really is an issue, and there was an issue also of fundamental fairness, and the Department of Water Resources may have information about how federal operations might be changing. We had to, people had to subpoena information. And I think really thinking about that is important. I know you've decided not to have discovery. In my own case, I know that there is information that DWR has about early discussions about where the intakes would be sited, and very early. And it's just, there's a question of, I mean, I actually produced information in the water fix hearing that contradicted DWR's witness testimony. And it's a real issue of fairness. So this is something that hasn't really been brought up, but as we go forward, it really was an issue in the hearing. I think we might know more on February 18th, but I kind of wanted to flag it as a potential issue.
Thank you, Ms. Desjardins. I just did want to clarify that I don't think we've talked about discovery at all that you raised. I haven't, to my knowledge, I haven't expressed an opinion one way or another about the subpoena process. I don't think it's come up in our conversations, and you're right to note that there is a subpoena authority in certain situations, and it's been minimally used historically, particularly before the AHO and with State Water Board hearings, because we have the process. It assumes that there is an opportunity for thorough cross-examination during the hearing itself. You're right that there's a challenge when the people you want to talk to are not witnesses. So this may be something that comes up, but let's see. We don't have a case in chief, so we don't know who the witnesses are. So I think we should start with that.
I do expect it would be an issue, and there may also be a need for subpoena duces tecum for some kinds of documents. I don't think I did do Public Records Act requests. I don't think in a formal hearing that PRAs are the right process.
Why is that?
Because I've done Public Records Act requests and gotten partial and incomplete productions.
I would strongly encourage, forecasting forward of what may come up, strongly encourage submitting Public Record Act requests first before seeking a subpoena. I think that's with agencies that are subject to the Public Records Act, that's an appropriate way to get documents. And then if there are challenges or problems that come up that are appropriately within the scope of this proceeding, that's something that we could deal with procedurally. But I would encourage you to do that and get those in if that's an avenue you're seeking.
What I found was that documents were withheld based on Public Records Act privileges. There is a privilege where DDR can just not disclose things that on their judgment are in the public interest to be disclosed. And it was very difficult to even get a characterization of what was withheld. So we can try that, but it wasn't really appropriate for a formal proceeding in my viewpoint. I did try and get records contemporaneously while there were various processes going on, like particularly what during the initial design of the current project.
Thank you, Ms. Desjardins. Again, I don't want to provide too much in the abstract. We really need a concrete issue here. But I think the place to start would be a Public Records Act request if there are specific documents or topics that you're seeking information about.
Yeah, I did do a number of those. CSPA did one, I did some, and we had a partial production. There was definitely material withheld and DWR wasn't clear about what it was. But I can try it again. I'm just concerned about running up the clock. During the water fix hearing, people tried to do Public Records Act requests and there were delays in getting the information. That was also an issue. But I can provide more information on it. Thank you.
Yes, and there is a subpoena process, and that's something we can talk about if it's appropriate, but I certainly would hesitate to use that tool absent using another tool, unless it's not it isn't a good fit, as you point out. Ms. Alftenberg.
Yes, hello, Hearing Officer Kinsey. I just wanted to respond a little bit and speak up. As Ms. Desjardins noticed that I did not speak, even though reclamation had been discussed a little bit earlier. I hope everyone can appreciate the lack of information that I might have about after January 20th. I know that we are, we're parties, non-protesting parties at this current moment. That's pretty much all I know. And I will have to go back and look at the Cal Water Fix record. I would expect that we would not honor subpoenas. I think that we got them quashed before. But I agree with you, Hearing Officer, that, I mean, to the extent that we can use the federal Freedom of Information Act in lieu of the subpoena process, especially for federal government employees, that can be helpful. But just wanted to put out there that I'm here, I'm listening, and I lack the information that everybody else lacks about what happens after January 20. So thank you.
Thank you, Ms. Alftenberg. Ms. Bear.
Yes, this is on a separate point. I don't want to unduly prolong this meeting, but I just want to clarify whether we will receive a ruling or have an opportunity to explicitly raise the remaining jurisdictional threshold issues at the February meeting. DTEC Baykeeper and several other protestants have continually presented concerns about whether the board has jurisdiction over this proceeding, particularly since we don't yet know the scope or contours of the underlying right that DWR is trying to change, which makes presentation of evidence speculative. As Mr. Bush already discussed earlier, we have submitted responses to DWR's request for consideration, but the threshold concerns that we've raised go beyond that. And so I'm wondering if and when the AHO will issue a definitive ruling on those, since we believe that those should be resolved before evidence is presented.
Thank you, Ms. Bear. It's a good question how to I mean, it has been State Water Board practice to defer those types of issues to the end, which of course I can understand that you're saying, well, it's most efficient to address them now. If you want to bring, I'm hesitating to encourage essentially a motion to dismiss. I guess my question is, to what extent have you not already briefed the issues? It seems to me you've briefed the issues. You're asking here for a ruling on what has already been submitted. Is that fair to state?
Essentially, yes, given that we've argued that the board doesn't have jurisdiction over this proceeding to begin with, because the water rights are expired. And so I'm wondering if we will get a ruling on that before the hearing process actually begins.
I can do that. I mean, I think, well, let me ask this. Ms. Carroll, would you, to the extent you have not already, would you seek to respond to the arguments, presented by the protestants with respect to the jurisdictional question?
I mean, I would want to see what additional arguments, if any, are put forth, but I would assume that we would address this in hearing and via closing briefs also. I mean, ultimately, an order will be issued by the hearing officer and then the board.
Yes. It sounds like Ms. Baer is saying that to the extent that these issues have already been raised in pre-hearing conference statements. Well, and Ms. Baer, let me ask you this. Would this come up with respect to addressing the hearing issues in your January 20th filing on the hearing issues? Is that part of your intent?
I think so, yes. I mean, I think our position is that we still have threshold jurisdictional questions that we've brought up continually in our statements and that we've touched on in these conferences, and that, you know, jurisdiction comes before evidence. And so we're happy to present those again in the form of a sort of formal motion to kind of put that all together, if that's necessary. But, you know, we have brought them up every time. And so, yeah, we would like a ruling on that before we get to that point, since, you know, what's the point of having a hearing if there's no jurisdiction to begin with?
And yeah, and I need to go back. I think I had understood that the amended hearing notice, I need to go back and look at the extent to which the amended hearing notice addresses that issue. It may not have done so explicitly in terms of jurisdiction, but that is something I can roll into. It sounds like you have your arguments in paper submitted, so I don't need to create additional workload for anyone. And that can be something that's explicitly included in this ruling that we're talking about on the petitions for reconsideration and other things, a larger procedural ruling that is forthcoming. We can address
We would
it there.
appreciate that.
Thank you. I'm not sure who's next, but I'll go to Mr. Moore.
We agree with the point that Ms. Baird raised, and I'm glad she did, about the threshold jurisdictional issues that in essence relate to whether, given the expired permitting deadlines and so forth, DWR still retains the rights that it aspires to change in this change petition proceeding, which seems like a threshold matter that cannot necessarily wait until the end, depending on how the issues unfold between now and when the hearing commences. Let me just briefly relate that to the rehearing process, because there's a bit of a loose end there. We greatly appreciate hearing your confirmation today that you will be considering the objections to reconsideration that were part of our pre-hearing conference statements. I'll note that some of the substance of those does relate to this, you know, water rights permit deadline diligence problem that we have referred to in various aspects before. And we understand that you will be ruling on reconsideration, and then that we will get some sort of order on that. There was some suggestion this morning, I believe, that while reconsideration formally may not be available, some of the content of what DWR and SWC raised in their petitions might be considered in another way. And so we will look and see what comes out of that, but would certainly at least want to reserve the opportunity to comment further on that, or even to suggest further initial briefing on that, should it appear to be necessary when we submit our comments on hearing issues by the due date in January.
Noted. Thank you, Mr. Moore. And just to note that any ruling, what I envision, any ruling that's coming out of this process, and I think we're all on the same page, would be a hearing officer ruling, which means it's not binding on the board. So I was going to say any ruling would be without prejudice. That's one way of saying it. The board can do once it turns to considering a recommended decision and a final order, the board, these issues I think could be raised again to say, the hearing officer got it wrong. So in that respect, what we address here early in the process, I think is fair game for closing briefs as well. To put that out there, although we do need to resolve some issues and go forward with the hearing. They're resolved for purposes of the hearing. And then the board will make a final decision. I don't know if hopefully that didn't complicate things, but that's what I'm envisioning this process, because it is interesting to have a hearing officer that is different than the final decision maker. So just noting that distinction here. Ms. Meserve.
Thank you. I guess one thing, and maybe you said it and I missed it, but to the extent the hearing officer intends to issue another ruling or any clarification on the matters in particular pertaining to the jurisdiction of the board with respect to the diligence issues, it would be good to know when that, for our purposes and thinking about writing whatever we're going to put in on the 20th of January, when that might come out. So I hesitate to ask because I know everybody is slammed, but that would be good to know if you know. Having some time in between would be helpful.
It would be, yes, and I wish I could give you, it won't be until January, I can tell you that, because there will require some coordination. But I can understand that it would be quite helpful for all of you to know where I'm coming from on some of these issues to inform what you submit on the 20th with respect to the hearing issues. So thank you, and that's noted, and I will do my best to get something out as far in advance as possible.
Thank you. Just two other quick points. There was some discussion about FOIA and PRA requests, and I agree, we should try to think of the least burdensome means to get the information that protestants need. However, I would point out, especially with FOIA, it's kind of a black box in terms of actually getting the docs. Obviously, people need to submit requests that are narrowly tailored in order to get hopefully efficient responses, but it's fair. It's not uncommon in both state and federal requests to, have a year or more pass before receiving the document. So, we're just going to have to think about, if there's something you want, obviously we should do that. But if, the timeframes for receiving those documents is typically very slow, to the point that, sometimes we don't need or can't remember why we wanted those documents by the time they actually show up. The other thing I was going to mention and may come up later is that, the water fix record before the board is available online, is not in an FTP site. It is a very good resource, and many of us have, really advocated to keep that resource available as a library for various purposes. It also, I think, will serve as a useful library for this hearing. And so it might be something to think about in the AHO's office, how if there's documents within that library, if whether it's DWR or any of the parties want to refer to those, because there's a lot more than, the specific evidence around that proposal. And there may be efficiencies that could be gained by simply referencing those documents, or somehow having a category in the new FTP site for this iteration of the project. But I just point that out, that there's a whole library there, and there's a lot of kind of document processing and naming that goes on to create those libraries, that perhaps some efficiencies could be brought about for all of the parties and the board staff as well. If we could think about, if AHO's office wants to give direction on how to reference those documents. Thanks.
Thank you, Ms. Meserve. We'll think about that. one of the parameters that we have held ourselves to is that the AHO, the FTP site folder is the administrative record and it's all in there. And that's quite helpful for PRAs or providing it to the court that it's all in one folder. But you're right, there may be an opportunities for crossover and for AHO exhibits. And I would invite if there are any suggestions from all of you on an efficient way to do that, if you would, for example, propose that certain exhibits be brought in as AHO exhibits so that multiple parties don't end up bringing them in, that could be useful. So thank you for that. Mr. Busher.
Thank you. So Ms. Meserve asked my first question, so I appreciate that at least hopefully we will expect a further procedural ruling in the first half of January that the parties will have an opportunity to fold into their comments on the hearing issues. With respect to the hearing issues, is it your intent to issue a ruling kind of before that February 18th conference, or to discuss those hearing issues as they are raised and argued by the various parties as part of that, process day that may occur on February 18th?
My intent right now is to issue, if there are any revisions, issue, if any, revised hearing issues in advance of February 18th. It may not be, to the extent that parties want to respond, if you want to respond to each other's arguments, it depends what comes in. To the extent I think that the arguments we're beginning to see themes, right? That we're seeing similar arguments that are repeating themselves, to the extent that the arguments I think have been considered and are well briefed in the comments on the hearing issues, and it's appropriate to go ahead and just issue finalized hearing issues before February 18th, I will do that. I guess my answer is, now I'm going in a circle, which is, it's difficult to know. It depends the degree of change, and whether parties want an opportunity to respond to the comments that come in on January 20th. It may be what you're telling me is that there should be an interim deadline for written responses to comments on the hearing issues.
I'm skeptical of building in more deadlines before the March ones as we started. So I think that's what I'm suggesting is, right. Let's hear that out. Let's figure out what the hearing issues are and then move forward. But I will not continue to bang that drum any further than I have today.
Thank you, Mr. Busher. Ms. Desjardins.
Just as a matter of procedure, if one wants to refer to objections or motions filed in the water fix hearing, is it sufficient to just provide a link and the date? I hesitate to get into trying to include them as exhibits.
Right, I think you're right that those wouldn't be exhibits properly. I think maybe the thing to do, if you were citing to them in a procedural document, for example, it may be appropriate just to attach the particular ruling.
It was more in the nature of these were objections that were raised in the water fix hearing, procedural, because we're revisiting a lot of the same issues. And unfortunately, changes in, federal operations. There was arguments between the two hearings to pause the hearing because of some federal changes, and I'd have to go back and look. But it's not the ruling exactly, but that they were raised, and because the entire petition was withdrawn, in some sense, all of those objections weren't finally dealt with. And there was a petition to literally to stop the hearing. Fortunately, that was probably a unique circumstance.
And thank you for raising this. I can understand it may be helpful to reference some of these. Once again, what I'm thinking about is creating this administrative record that's whole in itself. I hesitate to accept links because then we don't have the links break, and then we don't have the documents for the court on review. So I think the thing to do, if you're going to reference certain procedural documents or related documents from the water fix proceeding, and not in a way that's evidentiary so much, but that goes to the hearing process. The appropriate thing to do, I think, would be to attach those to the motion or whatever it is that you're filing, or brief, or pre-hearing conference, and that would be the way to bring those in so that we have a complete record that has the reference documents.
Thank you.
Thank you. Mr. Bobker.
Thank you, Hearing Officer Kenzie. I just wanted to add, because Friends of the River did not submit a separate written statement regarding particular issues, I wanted to express our support for the position taken in the written statements of the DTEC Baykeeper protestants and of CWIN regarding the whole issue of the expired rights and diligence and jurisdictional issues around that, and whether in fact the process should be restricted just to the perfected rights in DWR's 1972 permit, and again encourage you to resolve those issues clearly before we proceed further. So just wanted to get on the record with that. I don't need to elaborate further. I think you know the issues.
Thank you. I appreciate it. Thank you.
Thank you.
I'm looking to the room whether there are other procedural issues, and then I'll lay out, I think, well, let me lay out, while you think about whether you have other procedural issues, I will lay out what I think is next, which is a procedural ruling from the AHO with respect to these petitions for reconsideration, with respect to these, what we're calling jurisdictional issues that have been raised, and the helpfulness to have such a ruling as far in advance of January 20th as possible. The next step will then be for the AHO to consider comments on the hearing issues, and we will also see DWR's initial case in chief submittal. I will plan whether it's in the procedural, probably within the procedural ruling. Well, I'm not sure. Either within the procedural ruling that comes out early to mid-January, or later, I will provide some guidance on the February 18th. Let me back up. I'm going to sit down and look at these issues. Think about February 18th. I think it's likely we will want to defer policy statements. I'm going to take a look at the calendar. I will try to get that information out to you with that early to mid-January ruling so that you are all on notice. And then either at that time or after January 20th, because then I'll have the advantage of seeing DWR's case in chief, I will try to provide some additional guidance about what I'm thinking would be topics for discussion on February 18th, and my thinking on some of the procedural issues, for example, cross-exam time limits. I don't know if I'll have any detailed thoughts at that point, but and then I will also try to lay out the information I would be requesting from all of you, such as a proposed order of go, which doesn't have to be fixed. I can understand the flexibility is part of this hearing process. Time limits, those types of things that will be laid out so that you can submit something probably about a week in advance of February 18th. And then we will go from there. February 18th will be a big discussion, I expect. Are there other issues to address either now or put on the to-do list? With that, then, once again, thank you. Thank you for your cooperation and professionalism today. I really appreciate it. I think we covered a lot of ground. I think this was time well spent. And I will, you'll be hearing from me in written word, and then I will see all of you on February 18th. Thank you very much. We're adjourned.
Thank you.
Thank you very much.
Thank you.